going to start with hearing arguments on the State of Ohio versus Dennis Auerswald. That's case number 18CA0033. Each party will have 15 minutes to present their arguments. Now you may reserve up to 5 minutes for rebuttal. If you want to reserve rebuttal time, let me know and I'll keep track of that for you.
Thank you.
You probably know the oral arguments are recorded and presented on our YouTube channel, so we ask that you stay behind the podium and keep your voice up. We have read the briefs and we are ready to proceed if you are. The only other thing I'll mention is if there's any mention of children, we ask that you use initials and not names.
Understood.
All right, you may proceed then.
Your Honors, good morning, and I would request 5 minutes if you could.
Very good, thank you.
Thank you. Maureen Auerswald has died several years ago. In any case where a person dies, and in this situation we're talking about a death ultimately by poisoning through ethylene glycol, there are any number of implausible theories as to what may have happened. But there have only, and always only, been essentially two plausible theories. That which was presented by the state through the grand jury and then ultimately won the day before the jury was one of murder. However, it was one that was based largely upon circumstances, some degree of opportunity and motive, and obscure actions taken by Mr. Auerswald after the fact. The alternative presented by the defense was one of suicide. That trial, unfortunately, was one that was tainted, as I don't remember whether any of you three were on the panel that decided the original Auerswald appeal, but there was an agreement by the 9th District that the trial was tainted by evidence not being presented to the jury from the defense, and that decision was an error. However, the court determined that it was harmless error. The unfortunate reality in any case is that when you have a decision on appeal where there is a finding of harmless error, we unfortunately are in a situation where a jury of Mr. Auerswald's peers never decided his case fairly. What we have instead is a best guess based upon reason and law by a 3-judge panel, and ultimately later through federal habeas and ultimately federal habeas appeal, as to what we think a jury would have decided, but we never know.
But counsel, that's the whole, well, not the whole point, but when you do a harmless error analysis, or you do prejudice or error analysis, however you want to look at it, that's a decision you have to make all the time. Was it prejudicial or not?
It shouldn't be.
And so you seem to be arguing, just now anyway, re-arguing the case from several years ago that it wasn't harmless error.
My intention was not to do so. My intention was to present the case history to get us to the point we're now at. The point we're now at has that same analysis essentially being done. Because Mr. Auerswald, after exhausting all possible remedies through the appellate process and then ultimately through federal habeas, has requested of the court, with the assistance of both a private investigator of very high repute and a laboratory that has been used by the state of Ohio to cover its overflow, Mr. Auerswald has used those two individuals and law and facts to argue that ultimately we will know much more about the case and be able to determine ultimately from a fairly scientifically reliable standpoint whether this was murder or suicide by simply doing a DNA analysis of the lip of the ethylene glycol container. This is a case where there was never found, now obviously when never found could mean it was destroyed, but there was never found a vessel in which ethylene glycol was poured. One explanation for that is tampering with evidence or something of that nature. The other is that it was drunk immediately from the bottle of ethylene glycol, which would be consistent with the suicide. the state,
Handprints on the bottle as well.
Of
You
course.
have to get there somehow.
exactly. There are, I mean, in theory, again, if we're going to the implausible, one could use a straw. But yes, I would think there would be various methods of determining whether or not,
Get the cap off, find your fingerprints on the cap.
right, any number of pieces of evidence. What the state has put forward, however, and what ultimately the trial court has done, is to again substitute their own opinion as to, at least in a theoretical sense, what a jury might deem to be plausible or implausible. And those things which they have put forward, I would suggest, illustrate the major problem of not presenting this fact pattern to common sense people, or at least anticipating common sense.
What I'm having a problem with
Sure.
is, how does this exclude? It's another theory, there's
Right.
no doubt about it,
Right,
but how does it exclude your client? The DNA, and that's what the statute requires.
right. Nothing ever excludes anyone. For instance, if there were two people who could have shot the gun, and there's DNA from one of those two people on the gun, the person who is innocent may have handled the gun at some point in the past. And the person who committed the murder may have used gloves or may have somehow managed to manipulate the gun to fire in a way where his DNA wasn't put on there. Unfortunately, the reality is we never know 100% in any criminal case. But we have a substantial enough reliability if we have evidence that seems very strongly, very compellingly to exclude one person and include the other. And usually, when you're talking about an either-or scenario, you're talking about excluding one by virtue of inclusion of another. A robbery I recently handled, there was a knife with DNA on it. The reason my client's charges were ultimately dismissed is the DNA through CODIS came back a hit to another individual who had much better opportunity and a much more serious record. That did not mean my client could not have committed this robbery, but it was substantial enough. If you have,
But that's what the police would determine based on investigation. What you're asking this court to do is reopen a whole, possibly trial, a conviction that's 10 years old and say, because nobody examined whether or not there was saliva of hers
Right.
on there. And I guess I'm getting at, just with your scenario with the knife, somebody stabbed somebody and then they claim suicide.
right,
And they put the knife in the victim's hands
right,
afterwards. So that knife is going to have that person's fingerprints as well as the assailant. That doesn't exclude, just like you're saying, that doesn't exclude the assailant from doing it.
well, I would
Just because
suggest,
her fingerprints or his fingerprints were on it.
I would suggest if her fingerprints with saliva, for instance, are on the lip of this container, that fact would obviously seem to be exculpatory. It would not necessarily in and of itself force a new trial. And there's a premise that we were asking for a new trial. Well, what we're asking for is that evidence. If that evidence is then coupled with the rest of the case, the trial court may very well make the decision that a new trial is still not warranted based upon some additional arguments maybe the state comes up to explain the DNA results. But if there is no, for example, no DNA from him, that would tend to suggest very strongly that she touched it, not him. Now, the state posited that possible scenario of planting evidence, if you will, of the DNA getting onto the bottle by virtue of some act of Dennis Auerswald. I would suggest that, again, we never know for certain, but it's 6 years later. This would defy logic for a man to plant evidence against his wife and forget about it, or to somehow lurk for 6 years, planning a very, very difficult maneuver to possibly be able to prove that the evidence that he planted exonerates him. That would be something you would raise right off right off the rip with your defense attorney. Hey, they don't have the bottle, or they don't have the glass. Let's take a look at the bottle, maybe there's DNA on that. You wouldn't wait 6 years for that and suffer a much more difficult standard. I mean, it's real easy to get a DNA analysis. You just hire a DNA expert. And he's already shown that he has the funding to do so. State also posited.
We're at 5 minutes, 30 seconds right now, so.
Okay, I'm gonna, I guess I have 30 seconds because I can only reserve 5 minutes.
No, you can keep going, just to let you know where you're at.
Thank you, Ernie. The other point I would make is one of their other theories had to do with suicide not being a crime. I would suggest that not only is that one of the stranger arguments, and the fact that the trial court adopted that is very strange, but if we go down the rabbit hole of theoretical suicide is not a crime, we answered that. Abusing harmful intoxicants, because this happens to be ethylene glycol, abusing harmful intoxicants would in fact be a crime, even though it was not the indicted crime. It would be the manner of ingestion of the substance that caused the death. I would suggest that down that rabbit hole, there are, if you will, there's a Mad Hatter and there's the Mad Capper, and they're close enough. And I would suggest that that theory was unreasonable. I'll reserve what I have left.
All right, you have
Thank
4 minutes and 16 seconds left.
Great, thank you, Your Honor.
Sure. State has 15 minutes.
Thank you, Your Honor. Good morning, and may it please the court. I'm Vince Felucci with the Medina County Prosecutor's Office for the appellee of the state of Ohio. I'll just go to that last point real quick because that's one of the many sections of the statute. We're talking about 295374, and there's several sections in there that you have to meet to even get over the threshold to have this testing done. And there are multiple sections that are not met here, but C3 requires that the identity of the person who committed the offense must have been an issue at trial. The identity of the person who committed the offense was never an issue at trial. The state alleged that it was Auerswald. Auerswald's defense was the same that it is now. His wife drank the antifreeze and committed suicide. But, suicide is not an offense, and therefore, even if the theory, Auerswald's theory, was accepted, Maureen would not be a, quote, person who committed an offense. It does matter that abusing harmful intoxicants was not what was indicted. What was indicted was murder. That's what the case had to do with, not that. So the only thing that matters is murder. Would somebody else have committed murder?
So you're saying the statute with DNA exclusion could never be used in a case involving murder versus suicide?
I'm not saying that could never happen. Well, maybe I am. Because
That's all right, I do the
yes,
same thing.
I think I am saying that, yes, because suicide is not an offense.
I just have a simple question. If all of the testimony was that she called and said, I don't feel good, if she was gonna commit suicide, why did she do any of this? This is just, I'm sorry, I'm just thinking out loud, never mind.
Right, this is, I think, you start with the definition of exclusion, first of all. 295371G defines that. As a result of DNA testing, that exclusion is defined as a result of DNA testing that scientifically precludes or forecloses the subject offender as a contributor of biological material recovered from the crime scene or victim in question. Auerswald is asking to have the lip of this antifreeze bottle tested not to exclude him as a contributor of biological material, but to specifically test for another specific person's DNA, his wife Maureen's DNA. That is not at all what the definition of exclusion talks about. A test for another person's specific DNA is not allowed under this statute at all. Now, so that's one section we're talking about. In fact, exclusion appears a few times. That term appears a few times. So there's a few sections that he's excluded from, just based on that definition. You start though with section B1, that's the very first one you have to look at. And you start with the premise, first of all, this wasn't a DNA case. The DNA was not used in any way in this case to convict Mr. Auerswald. Auerswald did not have a DNA test taken during his case, and that's important because that's how you determine whether B1 or B2 applies. So B1 applies because he didn't have a DNA test taken. That section, and I apologize for quoting the statute again, it's just this is very heavily statutory here in terms of what it allows. It says, it requires the offender to show that DNA exclusion when analyzed in the context of and upon consideration of all available admissible evidence related to the subject offender's case would have been outcome determinative at the trial stage in that case, and at the time of trial, DNA testing was not generally accepted. The results of DNA testing were not generally admissible in evidence, or DNA testing was not yet available. Now, Auerswald was indicted on, as you mentioned, almost 10 years ago now, June 30th of 2010, and he was convicted in April of 2011. Auerswald cannot show, and hasn't even attempted to show, that at the time of his trial, DNA testing wasn't generally accepted, because it was.
What about this specific type of DNA testing that he's requesting? Was that available at the time of trial?
I think it was just as available as any other type of DNA testing, to take a swab off of a physical item. I don't think that's anything that's novel in any way, or that is new, or that couldn't have been done. It just wasn't done because, frankly, the police knew that Mr. Auerswald's DNA and his wife Maureen's DNA was going to be all over the house. They lived there.
So they could test for saliva, and I guess that's what would be happening here. The same testing was available at trial as it would be now.
Yes.
It hasn't improved. The testing procedure, the testing results haven't improved over time, where you have a more specific finding now.
In
Not sure
terms
if I'm
of
making myself clear.
in terms of, are you talking about DNA in general, or in terms of just saliva specifically? I don't think there's any evidence of either of those things with Mr. Auerswald's application, and he's the one I would say that has the burden to show that there is something that they could do now that they couldn't do back then. There's no evidence of that in the record, Your Honor.
You put it much more clearer than I. That's exactly what I was looking for, so thank you.
And again, the results of DNA testing were not generally admissible at the time of trial. They were. They've been admissible for many, many years. And again, it's his burden to show that, and he can't show that. He can't show, and he hasn't attempted to show, that DNA testing wasn't available at the time of his trial. No, that's a very general thing. Was it available at all? Sure. We know that it was. So we can't show that either. Now, on the outcome determinative part of this, he essentially argues that if his wife drank antifreeze, she would have put her lips on the spout, would have drank it in that way, which would have left her DNA on that spout. I think he even mentioned she could have drank it from a straw, so that's interesting, I guess. But so therefore, there had to be suicide. Well, even if the DNA was somehow found, let's even take this leap of logic that the DNA was found on the lip of this bottle, that would not make this outcome determinative in any way. And I talk about numerous potential scenarios. I know this court mentioned, I think just in this argument about, I forget which judge, I think Judge Schaefer, but it could have everyday handling and touching of this bottle could leak DNA. Now, he's asking something a little bit more specific in terms of saliva, specifically on the very lip of the bottle. But now, in terms of that, I mentioned in my brief there was a lengthy history laid out by the state trial of Mr. Auerswald abusing his wife, Maureen. And given his history, I don't think it's very implausible that Oswald could have forced his wife to put her mouth or her saliva on the lip of that bottle, or even forced her to drink from the bottle. Or as part of his premeditation, he could have easily obtained her DNA or her saliva from somewhere else, and then put it on the bottle. The other problem is, it would be impossible, I think, to determine exactly what day and time the DNA got on the bottle. That's very important, because the whole case is based on this date, February 9th of 2009. That's the day that this whole thing happened, that she started feeling these symptoms and eventually passed away at the hospital in the wee hours of the morning. It wouldn't prove that on the specific day in question, Maureen drank from that bottle. She could have put her lips on that bottle on a completely different day. She could have put her lips on the bottle and decided not to go through with it. She could have drank some, but not all, or not enough to be fatal. I guess there's just numerous scenarios that show that that could explain that very easily and plausibly, that would not make this outcome determinative. Because it wouldn't exclude Mr. Auerswald, frankly. That's how you get something that's outcome determinative. The statute also says that the DNA result will have to be analyzed in the context of and after consideration of all the evidence in the case. So the evidence against Auerswald, and I lay it out really in my statement of facts. I'm not going to get into all the facts of the case now, but there was compelling, overwhelming evidence of Mr. Auerswald's guilt. None of that had to do with DNA. Like I said, it was not a DNA case. So to look at all the evidence, and I think the trial court did a good job too of laying out all the facts of the case and why there was overwhelming evidence in this case, and that's also another consideration for why her DNA on there would not be outcome determinative. Section C1 is another one. That's another section that Auerswald does not meet. It says that the biological material must have been collected from the crime. It says biological material must have been collected from the crime scene or victim in the case, from which a sample of the defendant can be compared. That didn't happen in this case. There was biological material taken from Miss Auerswald when she went to the hospital as part of her treatment, and then later as part of her autopsy, certainly. But it wasn't ever taken at the scene or anything like that. There was no for forensic purposes.
Of course, the bottle was taken. And if the bottle contained her saliva, wouldn't that meet C1? It was collected as part of the evidence, I'm assuming. The bottle was part of the evidence.
But there was not biological material collected from that bottle. So I don't think the bottle itself is biological material. There's no evidence that there is any biological material on it. It's a bottle of antifreeze. It's a
So you're saying he should have requested the testing back at the trial date?
I think so.
Because that's the whole purpose of the DNA test, would be to determine if her saliva is there.
Again, even if he requested it, the police wouldn't necessarily have to comply with that request, I don't think. But the fact is, you can't go back and change history. It wasn't taken at the time. You can't look back in hindsight and say, well, I wish it was, because it wasn't. Again, he's not requesting that any biological material be compared against his DNA to exclude him. He's requesting that the lip be tested for his wife Maureen's DNA specifically. So section C1, again, is another section that doesn't contemplate the kind of testing that Auerswald is asking for. It's talking about comparing biological material to his DNA, which is not what he's asking for here.
Well, ostensibly, if they did test the bottle, and I'm guessing they would probably test more than just the lip of the bottle, fingerprints are not, hypothetically, not on the bottle anywhere.
Well, I believe the bottle was tested for fingerprints. It wasn't tested for DNA. And I believe there were not fingerprints found in the bottle.
Was tested for fingerprints.
I believe so, yes. But not DNA. And I believe the contents of the bottle were tested to make sure that it was ethylene glycol. It was antifreeze in the bottle. That was tested, and I believe the outside of the bottle was tested at BCI for fingerprints. But it was never tested for DNA. There was never samples taken from the bottle or the lid of the bottle to check for DNA.
About a minute left.
And again, I think C3 and C4, as I mentioned, also don't apply. The identity of the person who committed the offense must have been at issue in trial. The person who committed the offense. So he's not saying some other person murdered his wife. He's saying, in his theory, that his wife committed suicide. That would not be another person who committed an offense. Suicide is not an offense. And it doesn't matter. The abusing harmful intoxicants, I think, is a total red herring. That's got nothing to do with this case. It's not an offense, it's the offense, committed the offense, which is murder. That's the only thing that anybody was concerned with in this case. So that's the offense that was of issue.
With that, your time is up. Thank you.
Thank you, Your Honor.
And counsel, you have 4 minutes and 16 seconds.
Thank you. Judge Schaefer, I'm going to guess what you were thinking out loud because it's something I went through myself when I was analyzing this case. And I would suggest that on occasions, despite our best intents always to look at things in a purely logical standpoint, sometimes if there's a particularly bright light in a room, it's hard to see past that bright light. And the bright light in this particular case is that things don't make sense as far as what Maureen was doing, except that I would suggest you think through a couple things. Number one, a person who commits suicide wouldn't necessarily want to admit to people they were committing suicide, so they might posit to their friends not feeling well. And then if she dies, well, she wasn't feeling well, instead of this being a suicide. The question, though, that has been bothering me throughout this, she was a drinker. Most people are. Unless you're 14 years old, you know what happens when you drink. I went to Scotland, and I love Scotch now because I went to Scotland. But there's very subtle nuances on the flavor. I actually saw something like 16 different options of saltiness, brininess. When you drink, you understand flavor. And you definitely understand the impact. Ethylene glycol is deadly alcohol. It is very sweet, and it makes you intoxicated just like alcohol. I cannot imagine a person who knows drinking juice and not realizing the flavor is off, not recognizing the impact of intoxication. There's certainly an implausibility to the fact pattern as presented by the state. Now, this doesn't necessarily impact the question presented to your honors today. However, I'm often in fear that the big picture, if it looks bad for my client, the big picture oftentimes blinds the analysis. And in this situation, I'm not so certain that the big picture actually blinds the analysis. The state has also, in their argument, they have urged that, well, there wasn't any biological material, or we don't know if there was any biological. The statute actually requires the state to determine whether there was any biological material. And I would suggest that if you have gathered biological material, because it turns out to be on any piece of evidence, if you have gathered it, there is in fact biological material, and the state's obligation to determine whether or not biological material is present includes therein at least a cursory analysis as to whether there is an ability to test an item by doing something in the nature of serology or a swab. And I would also suggest that in this particular situation, we are dealing with a man who has offered, although the statute doesn't allow the ultimate conclusion, we have offered to do the actual biological analysis ourselves. We have the funds to swab. We can have a state witness there to analyze. We have the funds to be able to pay for the state lab to do this. This has not been something where justice should not be governed by the ability of an individual to pay. However, in this particular situation, we have offered and have been unable to do our own analysis because the statute has been determined to require that the ultimate conclusion be on the basis of a state analysis. But again, if we were allowed to do this and actually swab, we could tell the court whether or not there's actual DNA information on there using a state. We haven't used just a fly-by-night. This is NMS Labs. If you recall, I don't know how much time I have, but if you
About 9 seconds.
State Lab ran out of time to test their drugs. NMS is who they went to test their drugs. I suggest they're reliable enough.
Gentlemen, thank you for your arguments today. We will take the matter under advisement. The clerk of courts will issue a decision, mail you a copy of the decision once it's made by the court. You can also check, of course, the Supreme Court of Ohio's websites. Again, thank you for your arguments.
It was a pleasure.
Thank you.